Hello everyone, I'm Dr. Rakhi Gupta. Welcome to my module on managing human resource or just human resource management. Before I go down with the next topic today, let me give you a brief of as to what we did in the last series or lecture. We talked about something related with industrial relation. We know that industrial relations it's just the relationship that exists between the management and the employees or the workers. Now the new name is employment engagement. We all know that. As I told you all earlier also that there is another subject which is known as the labor laws or labor legislation, whatever name you want to call it by, you can call it. But I thought of giving you the introduction to these concepts also if you're studying anything related with human resource management. So the topic that I'm going to talk about today is very, very pertinent again because the topic is all related with industrial disputes. So, however, there's a different act which is known as the Industrial Dispute Act of 1947. But to reiterate myself, these are the acts which were earlier, but now new labor codes have come into existence. So, in case if you are going to study about new labor codes, so it is always desirable that one should have better knowledge of the earlier laws also. So let's go and check out few things related with Industrial Dispute Act. So when we talk about industrial disputes, my dear friends, it's basically any kind of conflict or a difference which exists between the management and the workers. And when we are talking about the Industrial Dispute Act, the difference is just because of the conditions related with the employment only. So since it is all related with the employment, you have to understand one thing, that in the Industrial Dispute Act, no act is good enough to settle down the things. But yes, Industrial Dispute Act of 1947 is basically an act that regulates the labor laws as it is concerned with all the workmen or all the people employed in the Indian industries. However, this act came into existence on 1st April 1947, and any kind of difference that exists between the management and the workers or the employees over the terms of employment or anything which is related with the employment is what known as Dispute Act. So in other words, what we can call it, it is a kind of a disagreement that exists between the two of them, and naturally this act was formed with the main objective of bringing peace. So whenever there is any kind of disagreement, we have to bring about the peace, and when we have the peace, we have the harmony. When we have the harmony, then definitely we have a very good working environment. So this act was again formed with the intention of bringing peace between the management and the workers. And we know that yes, in the last video also I talked about something related with the trade union. I told you all that trade unions, they are nothing but they are the platforms through which people actually raise their voices. So naturally we have talked a lot of things related with grievances also, and we know that if the grievances they are settled at the earliest, then it is good. If the grievances, the complaint or dissatisfaction is not settled, then it can take the shape of a dispute. And basically any dispute over the working condition or work of employment is what is known as the Industrial Dispute Act. It provides the solutions for it. And naturally this act is centered around any industry which is carried on or by the under the authority of the central government or by any of the railway organizations or concerning any such controlled industry as it might be indicated by the central government. So Industrial Dispute Act is pertinent to the disagreements which exist between the two people. And then this is a new word that you can see on the screen, industrial unrest. So this unrest is also like anything which is uncomfortable for both the management and the workers, and it manifests itself in the form of strikes, lockout, picketing, gherraus, indiscipline on the part of the workers. If you all remember, we had already discussed about things related with indiscipline, or we had discussed misconduct also. So this is more or less the same thing. And lockouts, they are basically the weapons in the hands of the management to let workers follow what they actually want. So here, according to section 2K of the Industrial Dispute Act of 1947, it defines any difference between employers or between employers or workmen and workmen. So they are all connected with the employment employment, and definitely we know that basically there are three parties involved in this. So Workmen Industrial Dispute Act, since it's just an disagreement that exists between the two, it has to be solved at the earliest. So naturally there are two disputants, that is the labor and management, and anything which is it can be any kind of matter which is related with individually or collectively. So we all know, my dear friends, in the case of dispute act, any matter which is at the individual level, no individual employee or worker has that kind of a powerful say. So that is why they actually get associated with the trade unions, because they can voice their problems, they can tell about their discomfort to the management. So ideally, Industrial Dispute Act, it can be related with an individual, but however, more or less it's in a collective form only. So it should be noted that the subject matter of the Industrial Dispute Act should be very, very specific, and this specific is basically what we are talking in terms of the anything which is related with the employment. It can be wages, it can be benefits, it can be incentives or working condition, whatever you may call it. Then from the point of the view of the employer, an industrial dispute resulting in the stoppage of the work. Now, stoppage of the work basically means stoppage of production. So we know that when there is stoppage of production, naturally it is a big cause of concern for the management. Reason being that there is so much of money which is at stake. The management has put in so much of money in the manufacturing or in the industry or in any organization. So at any point of time, if the production stops, so there can be huge losses which have to be suffered by the management. So of course any kind of losses is not at all desirable at all. So because as soon as the production stops, it will increase the cost of production, and when the increased cost of production is there, so naturally your profit margin go down. So under section 2S, there's a word which is known as the workmen. So ideally the expression workmen signifies any individual who works in an industry who needs to do anything which is manual or unskilled, specialized, operational, administrative, supervisory, so on and so forth, for the contract or reward. So this is a definition which has been given in the Industrial Dispute Act of 1947 only, and any kind of dispute arising because of these factors, it's all in the connection with the industrial dispute, and of course it incorporates any person who has been expelled, released or saved regarding as on the outcome. So anything which is related with these aspects, anything related with operational, anything related with administrative, anything related with supervisory, they are the ones who will fall under this category. And however, it says that in this workmen also, there are people who are not included. So who are the ones? So anyone who is subject to Army Act of 1950, or who is employed in police service as an officer, or who is employed mainly in the managerial or admin capacity, or a supervisor drawing wages exceeding a specific amount. So these are the people who actually don't fall under this category. And as an individual, there are different figures which have been set by this act, but of course this act, there have been number of amendments also, and now new labor codes have come into existence. So it is just for the purpose of your understanding that I'm talking about these words. So it says that an analysis of the provision of the Industrial Dispute Act of 1947 is basically a dispute among them only, and of course the industrial dispute is connected with employment, non-employment, or terms of employment or conditions of labor at any point of time. So in all of these you see that what is the most important part is the interest of the worker or the employee. So when we are talking about this, you should also have a broad idea of what is the meaning of industry. So it's like any systematic activity carried on by cooperation between the employer and his workmen for the purpose of production, supply or distribution of any kind of service will fall under this category. But again, when we are talking about the industry, there are a number of things which we have to bear in mind, that there are a number of activities which actually do not fall under this purview. And these industrial dispute acts which is there, generally it's not applicable to them. For example, any agriculture operation is there, hospital, dispensaries, khadi, or maybe any kind of training institutes, or maybe any sovereign function of the government, domestic services, cooperative society, or maybe any profession practiced by an individual if the number of person employed by the individual is less than 10. So all these things, they will not be incorporated under the term of industry. But however, in these places also there can be conflict of interest. So now once we are talking about the industrial dispute, my dear friends, we need to understand that who are the people who are here, or what are the essentials of the Industrial Dispute Act. So we know that Industrial Dispute Act is an Indian act which has been initiated, and the main purpose, or the Indian law has actually come out with this act, which basically tries to regulate the resolutions of the Industrial Dispute Act between the employer and the employees. So the first most important essential of any dispute act is that there should be parties. So if parties are not present, so naturally there would be no dispute, and when there is no dispute, we do not talk about the Industrial Dispute Act at all. So for example, the next one is the relation. So naturally here, since we are talking about the parties, there can be any kind of conflict that can exist amongst them. So there has to be some kind of relationship. So matter of dispute may relate to the worker or the employer, or to both. Normally it is related to the appointment, termination of the person, conditions of the employment, and condition of the work. So these are the primarily four concern. So when we talk about the conditions of work or condition of employment, so all those things that we can think of in terms of the person, they will fall under this purview only. So and we have to understand these things, they can be related with wage demands, they can be related with working hours, safety condition, job security, or anything which is related with their crash facility, transportation. So ideally, what we can say in a nutshell, it's all related with the health, safety, and welfare. So generally these are the three things which are a matter of concern for the parties, and naturally we know that both the parties, they will get affected, or their rights, they get affected, and naturally it will have an impact on the overall functioning of the industries in the country also. So there should be some kind of relationship that should exist. Then the form of industrial dispute is like, for example, there can be strikes, there can be lockouts, gheeraos, go slow practice, or so on and so forth. So my dear friends, when we talk about the industrial dispute, we know that there can be number of ways by which the production can be hampered. One thing to note here is that both the parties, whether the management or the workers, they have got powerful weapons in their hands. So when I say powerful, what do we understand? We know that these workers or employees, they are in unity, and they are raising their voices collectively for any particular reason. So one of the biggest weapons that they have in the hands is the strikes. There are a number of strikes that I would be discussing in my future lectures also. So strike is like, for example, it is a go slow strike, or pen down strike, or the stop production strike, wildcat strike. There can be number of strikes. So naturally at any point of time, if the strikes are there, or the production is stopping, or the work is stopped by the workers, so naturally at that point of time it will be a loss for the management, it will be detrimental to the interest of both management and the workers, and ideally the cost of production would increase for the management, and we know when the cost of production will go up, the losses would definitely be higher, or the profit margin will be very, very less. So this dispute, one of the another essential of dispute is that it can be oral or written. So industrial dispute need not be written. It can be oral, and it can be quite apparent. People can feel that my people are not happy, and they can actually feel that at any point of time any action can be taken by the person. And we know that in Industrial Dispute Act, this act also primarily applies to workmen who are actually involved in any kind of manual, unskilled, skilled, technical, operation, supervisory, as I already told you. So any conflict arising out of these jobs, so naturally it's not necessary that it has to be in the written form, but it can be oral also. Then another essential is that it should be real. Nothing fabricated, nothing disguised, nothing implied. So naturally it should be related to the terms of employment, and these terms of employment, as I told you, it can be the conditions of work related with wage, bonus, incentives, perquisites, appointment, termination, so on and so forth. Then there should be substantial interest in matter relating to industrial dispute. Interest either of the employer or the worker must be involved. So if it is any kind of matter which is related with the only with the employer, and where the employee is not concerned, so naturally it's of no use. Then it should be related to the industry. So any kind of dispute which is there, it should be related with the industry. And in the previous slides, I have told you that what is the meaning of a industry. But one thing to keep in mind, my dear friends, that this industry should be functioning. Any industry which is shut down, so naturally there's no say. So it's not included, or any industry which has been on in operation for a long time, it is not included. Then clarification, industrial dispute should relate to matters which are very clear. Unless it is a transparent case and settlement is not possible, matters which are clear, find settlement easy. So my dear friends, we know that at any point of time when disputes are there, so we are trying to get a solution for it, and there are a number of authorities, there are a number of ways by which we can actually settle the disputes, or we can prevent the dispute, because any kind of dispute will bring losses, or it will have adverse effect on both the management as well as on the workers also. So there can be different types of industrial disputes. So industrial disputes have been classified on the basis of maybe on different grounds they have been mentioned, and we have to understand that there are a number of authorities, there are a number of courts, there are a number of tribunals who are involved into this in bringing the peace and harmony after the settlement, or they are trying to settle the dispute in a very, very fair and a just manner. So I just gave you the example of a strike, that a strike is the biggest weapon that they have. So at times people, they start participating in the illegal strike, which is not at all desirable. So here any kind of authorities who are there, they play a very, very crucial role in mediating peaceful resolutions of these industrial disputes. So naturally authorities, they facilitate negotiations, they try to do impartial settlement, or of course they take steps to prevent disputes from escalating. And if escalation goes on, so naturally things become from bad to worse. So ideally these industrial disputes, they are of the interest disputes. So these conflicts are also called the conflict of interest or economic disputes. So now when we are having this kind of economic, so when we talk about economics, so we know it's anything which is related with money. So these disputes, it can be related with the new terms and conditions of employment of the workers, which can actually affect the masses. So as I told you, this dispute, it can be individually also and it can be collectively also. But in the case of individually, naturally the probability is very less that they would be hurt, but once they do it in a collective manner, so naturally they have got more power, and then the management also feels the pressure that they have to listen to the workers and provide what they're asking. But it cannot be just one-sided. So the interest disputes, again, it's all related with the economic disputes, and it can be, for example, it can originate from the proposal of increase in the wages, emoluments, fringe benefits. My dear friends, if you remember fringe benefits, we had talked about that fringe benefits are the benefits which are given to the employee over and above their salary, and these fringe benefits, they can be in the form of monetary benefits as well as the non-monetary benefits. So any kind of benefit that one gets over and above the salary, one always likes it. So they can also be one of the economic causes of the dispute, or they are the types of interest disputes, that's what we can say it. Then these demands are put forward by the trade unions with the view to negotiate. Negotiate is basically bargain, and that bargaining is only known as the collective bargaining, and disputes, when the parties fail in the negotiation, reach an agreement. So I will be covering this collective bargaining at length also with you all in my future lecture. So any kind of interest where workers are concerned, especially with in terms of money, so they will fall under the interest disputes. Now, another type of disputes that we have is all related with the unfair labor practices. That is, it says that these disputes, they basically arise when employers engage in discriminatory or unethical treatment of the employee. So unethical kind of treatment, if it is there, nobody would like to entertain, or nobody would be happy to see that kind of discrimination coming from the management side. So for example, if there is an unethical treatment or in discriminatory things are there, treatment is there, for example, restricting the employees from joining a trade union. So it's a kind of an unfair labor practices which they have to avoid. So here in the dispute over unfair labor practices, what is more important is discrimination. So if management does any kind of discrimination, so and actually it is not at all entertained. So this could be, I gave you the example of that people are restricted from joining the trade union, or interference is there, restraining is there, coercion is there. All these things, they fall under the unfair labor practices. Or also, if you can see on the screen, it's mentioned that the employer sponsored union coerces the workers to join such a union. That means there is a force, or management is forcing the workers to join the trade union. This is not acceptable, because we know that trade unions, they are the platforms through which the workers, they actually raise their voices, and it is a voluntary step. So any kind of coercion coming from the employer side, that would be a matter of concern or a dispute over the unfair labor practices. Or at times, if the management feels that they do not wish to bargain, then also it's a matter of concern. Or recruiting new people or employees during a strike, which is not declared illegal. So we know that generally strikes, they are legal strikes, they are illegal strikes. So, and both legal strikes, they come with their own benefits and own privileges. You need to understand this. So here any kind of unfair labor practices done by the management, it will fall under this. And at times the management can always shake hands with the trade unions, and then they can always grind their axes or get things as per their own concern. So we know that in a nutshell, that in the case of disputes also, since it's all related with economic aspect, I'm just reiterating, it can be related with bonus, incentives, wages, leaves, indiscipline, violence, and at times when management starts practicing these unfair labor practices. So naturally, this is a matter of concern for everyone. Then we have got something known as the grievance or the rights dispute. So they can be actually in disputes of interest also, or dispute of right also. So these are basically the legal disputes that we can call them, and they involve individual workers or group of workers in the same group. So ideally, what happens, my dear friends, that in this grievance, these disputes arise when employers, they fail to fulfill workers' rights. So if at any point of time workers' rights, they are at stake, so naturally it's a matter of concern, and primarily it is all concerned with, for example, it is concerned with timely payment of wages. Money has to be paid well on time, or anything which is related with promotion. We all know there can be some time-bound promotion, or it can be on the basis of seniority or on the basis of merit, or anything which is related with the dismissal. So any kind of such things happening, they will fall under this category. And as it is mentioned also, that the such disputes arise from the day-to-day working relation of the workers and management. And naturally, when they feel that their rights, they have been violated, then they come into play. So basically, grievances typically arise on such question of discipline, promotion, transfer, dismissal of the worker, payment of wages, fringe benefits, overtime, retirement benefits, seniority, work rules, and so on and so forth. For example, my dear friends, if you all remember, we had also talked about that there can be some concerns when social security measures are not taken by the management. So ideally, they are also the right. For example, there can be payment of Gratuity Act of 1972. There is a Workmen Compensation Act of 1923, or the Employee State Insurance Act 1948, Maternity Benefit Act 1961, Payment of Wages Act 1936, Factories Act 1948, Minimum Wages Act 1948, Employees and Provident Fund, so on and so forth. So ideally, this is the right that they actually have. And when the management actually they violate such things, then of course there would be a kind of resentment among the workers or employees, and then they will join together, or they will raise the voices. Then Another kind of disputes, it can all be related with the recognition disputes. So here is again quite apparent, where it is said that when management fails to recognize a trade union. So my dear friends, we know that trade union is a very, very important aspect in any of the industrial organization, and at any point of time, if trade unions they themselves they are not recognized, then it's a big matter of concern, because we all know that it is with the help of trade union that all the workers they are attached to it, and of course it's a kind of a common platform through which they get united. They can always put forward their demands to the management, and trade unions they act as a mediator between the management and the workers. So if trade union themselves they are not given any kind of recognition, then it's a matter of concern. So recognition issues, they are basically for the trade union, and it says that when these trade unions are not recognized, and we know that trade union they can always put forward the individual dispute concern or the collective dispute concern to the management. So naturally when we talk about the collective disputes, so these disputes they will involve a group of workers whose rights and interests they have been contravened by the employer, and at times the trade unions they can also help an individual also fight for their rights. For example, as I told you, that there can be certain disputes which can be related with the dismissal, discharge, termination, promotion, security measures, retirement benefits, as I told you about the social security measures which are there in the country also. So my dear friends, that's all that I have got for you all in this lecture. So in this lecture of Industrial Dispute Act, I hope you are very clear that what is the meaning of Industrial Dispute Act and who are the parties to it, what are the essentials of industrial dispute. So ideally we know that any kind of dispute that exists between the management and the workers over the work of employment or maybe non-employment, they can be a part of it. And we also know who are the people who are concerned or who will be falling under this purview, and we also know what is the meaning of a worker, workman or industry, or of course we also understand which are the different type of disputes that can exist in the industry. So thank you so much for watching this video. Stay tuned for more on Industrial Dispute Act. Thank you so much.